there are quite a few misconceptions that people sort of intuitively bring to the subject, which I think it's quite useful to dispel, and in dispelling them, hopefully it sort of gives some pointers. Then I want to say a bit about regulation, which is the big thing at the moment, and how it's sort of disappearing down a bit into 1,000 foxholes of different sort of areas. And then just have a look at the legal areas of AI, focusing really on agency, contracts, intellectual property and tort. Because as with most sort of transactional technology, contract is king. So an understanding of those areas really informs, I think, what you and your businesses will be looking for in terms of those contracts. So there are a number of misconceptions here. People tend to think of AI as a person. This is sort of popular culture, and businesses like to anthropomorphize AI because it helps sell, it helps people get intuitive with it. So to dispel this fallacy, I think people need to think of big data and software rather than human and brain. The thing that sort of really unlocked AI and its legal aspects for me was when someone said, it's only AI until you know what it does, then it's just software. And I think that's a really good sort of way through, if you like. It's actually software and lots of data. So if you're thinking about sort of conventional software and working with lots and lots of data, you won't go that far wrong in legal terms. And then, again, largely from popular culture, there's what you could call the agency fallacy, sort of imputing rights and duties from actions. Agents, you tend to think of them as people, and an agency relationship has to be between two people, two legal persons, the principal and the agent who's acting on the authority of the principal. But an AI is a thing. There is property. If it's mobile, there will be property in the goods, and there will be intellectual property rights in the software. So the sort of iRobot fallacy, don't anthropomorphize. The agency fallacy, don't think of the agent as a legal person. It's a thing and IP, personal property. Then the last one is really the entity fallacy. There was a sort of a later version of Bitcoin called Ethereum, who have been commercializing this thing called the DAO, the Distributed Autonomous Organization, as if their sort of their blockchain platform possessed separate legal personality. So these AI platforms, again, aren't legal people themselves. They may be owned by a legal person, but then they're just acting, it's that person acting. So a smart contract platform, for example, will be operated by, but it won't itself be a legal person. So I think you have to sort of bring it back. This is a new technology, and it's quite easy in the glare of that new technology to sort of forget temporarily the kind of legal, analytical and thought process tools that we bring to these things. So sort of simplify it down a bit. Don't get too caught up in the glare. So regulation is probably the big thing for AI, and it's incredibly broad. It's quite difficult to sort of put four corners around it. When you start to think about the ethical and the social and the economic macro implications of AI, it becomes more difficult still. So, as you'll have seen in the white paper, we sort of pushed that to one side. Although one has to say that the sort of at the macro level, the political and social consequences of AI use are likely to generate political and policy drivers in the future, and that's one for down the pike. So I think coming at regulation sort of from the top down, we're looking at a number of questions. And in October last month, the Office of the President in the States and the NSTC came out with two good reports, and that there are links to them in the paper, the Future of Artificial Intelligence report, which is actually sort of quite digestible and really quite helpful in this area. So they've sort of asked a number of high-level questions, the first two of which are, what interests should AI regulation protect? And sort of, do we tear up the rule book and start again, or do we use existing regulatory structures? And what interests should AI regulation protect? It's quite worth. This is something that we'd all get there to the right answer, but it's very clearly set out. AI has applications in many products, such as cars and aircraft, says the report, which are subject to regulation designed to protect the public from harm and ensure fairness and economic competition. So we're looking at risk in relation to public safety and health and fairness and economic competition. And on the question whether we start from scratch or adapt existing regulatory structures, they say if an AI-regulated risk falls within the bounds of an existing regulatory regime, the policy discussion should start by considering whether the existing regulations already adequately address the risk or whether they need to be adapted to the addition of AI. And part of the reason for choosing autonomous vehicles and legal services is that they are good examples, as we see in the case of cars, of adapting existing regulatory structures, and in legal services, really where we're saying, well, the existing legal regulatory structure covers it. The AI Futures report is quite concerned that the regulatory burden shouldn't have the effect of dampening innovation. So they're saying policymakers should consider how responses could be adjusted to lower costs and barriers to innovation without adversely affecting safety or market fairness. And then a particularly big point at the moment is, what role should government play? Should central government, local government? The risk is that you have distributed among the government departments a large number of smaller centres of excellence addressing regulation in that particular sector, and that's quite a difficult policy thing across the whole. So in the same day, actually, that the AI Futures report was published, the UK House of Commons Select Committee on Science and Technology came out with their own report, which is advocating a commission on artificial intelligence and a robotics and autonomous services leadership council. And they're saying it's much too soon to start to set down sector-wide regulations in this nascent field. And that's another real problem, which is, we don't know where it's going to be for any particular industry in 10 years, but we've got to start regulating now, so how do we do it? And autonomous vehicles is a good example of a pragmatic and probably a successful approach to that. This slide says AI, the fourth industrial revolution, and Brexit, bad timing for the UK. The reason for saying that is that a large amount of policymakers' time, the civil services time over the next 3 or 4 years, is going to get taken up with Brexit at the same time as all these really difficult AI questions need to get addressed. So just part of the reason that we took legal services and AI is that they're sort of poster children in their own way for a number of areas. Legal services, as Deirdre said, is sort of a poster child for static AI. It's at the heart of UK professional services making up 70 to 80% of GDP. And autonomous vehicles are a poster child, along with aeroplanes, for mobile or movement in AI. And in legal services, we've seen that there is this regulatory backdrop that all solicitors' firms operate under, the SRA's Code of Conduct, the Handbook and the Principles, and unless you have your own AI technology, which is going to be unlikely, the UK regime equates AI to outsourcing. Outsourcing is regulated under Outcome 7.10 of the SRA Code of Conduct. And these requirements will apply if you're in a law firm and that law firm is using the cloud, if it's buying any other forms of technology. So really, this is an example of existing regulatory approaches being able to cover use of AI without a lot of change. That's not to say that if you're a client using a law firm, you don't need to look at AI in terms of your contractual arrangements and engagement letters. It's a bit like any other form of software. The terms of engagement should be looking to expectations. What happens if a legal AI misses points in due diligence and misses a big point and causes the client loss, sort of negligence risk? So that's a little bit like if your law firms are using software in the provision of their services. Nothing really different there. For autonomous vehicles, the position is quite different. And the UK has really trumpeted its approach in saying we think we're out there among the leaders in the developed economies. And there are really three parts to the approach. The first is to ensure, as there are at the moment, no obstacles to testing or advanced driver automation systems or automated vehicle technology systems in the testing situation at the moment. So as long as there's a person in the car, the vehicle's roadworthy and all the rest of it, then ADAS and AVT technology can be tested. They've gone through a wide consultation process, which ended a few weeks ago, kicked off in the summer. And what they're trying to do, which I think is particularly interesting, is they're saying, look, we don't know what the field is going to look like in 2030 or 2025. We don't know what the developments are, but we're going to break down all the things that we need to look at into bite-sized chunks, and we're going to legislate for each of those at the right time. So that's why they're looking at insurance, to make sure that there will be insurance products available. They're looking at changes to the highway code that need to be made. They're looking to changes to the construction regulations. And I think that's the way to do it. You break the issue down into bite-sized chunks, and then you make sure that as we move along this path towards greater autonomy, that the regulatory aspects and the technology aspects are more or less aligned on a sort of ongoing basis. And I think one's going to find that will happen in other industries as well. So if regulation is a pretty key area for all of this, then I think there are three areas of the general law that will develop. And particularly if you're looking at AI contracts, if your business is buying in AI or starting to use AI in operations, then the sort of mantra is the same. Contract is king. You'll need to look at the AI in the contractual context in the same way as you do for software, for example. But these other areas inform it. So I think a good example of this is smart contracts, where the product, it's this example, as Deirdre's mentioned, of Chitty-on contracts in code. There will be a large number of elements that all have to be catered for in software, in code. These will be everything from all aspects of an individual contract's formation, so capacity, offer acceptance, communication of acceptance, and consideration, right through lifecycle issues to discharge, through termination, through breach, and otherwise. And if you're dealing with smart contracts as links, as blocks of these contracts, where the performance of any particular contract may be dependent on any other number of contracts around it or before it in time, then you have particular issues around contract dependencies, conditionality, and they all need to be coded into the platform to make it work properly. So if you're a platform operator or if you're a user, you need to make sure that you understand the user guide, and then you need to make sure that the terms for the use of the platform, and if you're a platform operator, you'll probably be dealing with the developer, so performance issues are really important. If you're a user, a bit like a member of any sort of clearinghouse or exchange, you'll have your membership agreement, and you'll have a whole bunch of guidance rules and ancillary contracts. But you need to make sure that the guts of it, which is this code, sort of contract code system, is working properly. So that aside, if you're familiar with software developer, build, operate, license as a service, that whole world of computer contracts, you can pretty much plug in AI use there without too much change. I wanted to say a couple of words about intellectual property and computer-generated works and computer-implemented inventions. AI will develop the field of machines being able to come up with copyright works and new inventions. Going to the answer at the end of the book, again, it's to make sure that your contracts deal with all of this, with copyright aspects and patent and invention aspects, and the sort of life cycle of creation, ownership, assignment, transfer, and licensing. And you deal with those contractually, because the underlying copyright and patent position is actually quite complicated. So in the area of copyright, there is provision for computer-generated works. In the case of traditional copyright works, which are computer-generated, the author is taken as the person by whom the arrangements necessary for the creation of the work are undertaken. So, there's quite a lot around that. What does, what arrangements are necessary? What does undertaking mean? And that's before you get onto this rather unsightly definition in section 178, which is that computer-generated means that the work is generated by computer in circumstances such that there is no human author of the work. And you can see the draftsman scratching his head and saying, well, how do I deal with this? I know, it'll be where there's no human involvement. So what does that mean? Does it mean in the presentation of the information on the screen? Does it mean in the computer language? Does it mean in intermediate code? There hasn't been a lot of case law on this yet. There have been some cases, but it's not really easy at the moment to see where all this will be going. So that points to legislating contractually for computer-generated works. With patents, it's even more difficult because before you get to the issue of whether the invention has been generated by a person, you've got this issue about whether computer software or computer programs are patentable. And if computer programs as such are not patentable under Section 1 of the Patents Act, but where you have a computer-implemented invention that contributes to the technical field of knowledge going beyond use of a computer program as such, then there's a line of cases over the last 10 years, starting with McCrossan, that says they are potentially patentable. So if it's not potentially patentable, I'm not concerned about it. If it is, and it's generally a computer-implemented invention, then we've got the definition of the inventor as the actual deviser of the invention, and joint inventor is construed accordingly. So that doesn't refer to a person. If you look at the equivalent language in the US patent legislation, then that does refer to a person. But they've this is 1977, so it's even before the CDPA, so they weren't really thinking about computer implemented inventions then. So those areas are likely to develop quite a lot in the next few years, but the answer is to make sure you deal with it in your relevant AI agreement. So the third area I wanted to look at just very quickly was tort law. And again, I think this is important if you're a manufacturer or developer of AI products, particularly if they're mobile, or if you're using AI products, and again, if they're mobile, what's the worst that can happen, sort of thing. And there are probably three things that are relevant. The common law duty to be careful. In Lord Macmillan's words in Donoghue and Stevenson, the categories of negligence are never closed. And it's hard to imagine how most types of AI won't be subject to that common law duty of care, which will be you'll need to look at both in the context of contractual obligations and in the context of restriction and exclusion of liability. The second thing I think is much more likely to be relevant with robots and mobile AI than sort of static AI in services. But if you have a robot and it goes off your land, or goes off your land, so 19th century look at it. But if it sort of knocks someone down in the street, or if your drone sort of knocks into something, then I think there are two things to look about. That the owner of that robot, or the operator of that robot, is very likely to have liability and nuisance where its robot goes off-piste. And the analogy there is with a straying animal. Now, the law around straying animals is codified in the Animals Act, this is Section 4. But really, there's quite a lot of common law around this. So if your AI goes off and escapes, then this is sort of Rylands and Fletcher liability, the escape of an inherently dangerous thing. And there's a bit more on this in the white paper, but the categories of thing, the dangerous thing that Rylands and Fletcher applies to is closed. It applies to cars, it applies to electricity, it's been held not to apply to aeroplanes, and not to apply to a cricket ball being driven out of a cricket ground. What happens to a drone? So I think there are quite a few issues here that in time you'll need to start thinking about in your contracts. But the sort of the wrap-up point on all of this is that don't get caught by the glare of AI. Think of it as software and data. I think that's a really good analogy. If your business is looking to do its first AI project and you're looking at the contract for it, then the software analogy, particularly in that contract wrapper, whether it's whatever the type of contract is really quite powerful. If you're an IP-rich company and you want to have the benefit of any software, copyright works, or inventions that the AI comes up with, make sure that you deal with that, you legislate for it separately in the contract.